Okay, I have 1 o'clock and we're going to move on to a presentation by Mitch Sickon. This is on the Perez case. Really looking forward to this one. So without further ado, I'll pass it on to Mitch.
Thank you, Mark. Good afternoon, everyone. Like Mark said, my name is Mitch Sickon. I'm a 40-something white guy. I'm wearing a white shirt, blue cardigan. I've got dark hair, brown eyes. I'm also wearing a blue tie with a pink stripe on it. And I'm an attorney here at Edmund R. Weichert. My practice focuses on K-12 special education matters, though I also practice K-12 discipline and am incorporating other elements to my practice, such as employment law and higher ed. I'm here to present on exhaustion, futility, and the pursuit of fate. We're going to talk a bit about that Perez case that Mark mentioned. I was a counsel on that case that ended up getting to the Supreme Court. And I'm going to walk us through some of the facts underlying that case up to the decision to litigate, kind of walk us through some of the litigation, the decision. And then I'm hoping to get to the after part where we get to, after 2023 and the decisions made. We also have an opportunity to see how other courts have interpreted what the Perez decision means, and discuss like um, the title of the webinar, exhaustion, futility, and damages as well. All in the pursuit of getting students with disabilities a free, appropriate public education. So uh, we're going to start with Miguel's story. And so, oh, I forgot. Fun fact about me. Um, I am into yoga, but I still like pina coladas. Um, and we're gonna go back in time now to meet Miguel, who was the client in Perez v. Sturgis schools. And we're going to meet Miguel at the doorstep of the public schools there in Sturgis. Sturgis is a bit of a rural town. It's in south central Michigan, right close to the Indiana border. And Miguel and his parents moved there from Mexico when he's about 9. And there's a lot of information in these slides and some of the other slides. I'm not going to read them verbatim. I'm going to kind of give a general overview of some of these facts. I want to make sure that we get to the end, and if folks have questions, they have time to ask them. So the important thing to know about Miguel is that when he arrives, he has no other disabilities other than being deaf. He also didn't receive any formal education in Mexico. He didn't have any knowledge of any sign language. When his parents came, they were hoping to bring him to a place where he would have more opportunities and more supports. The initial cognitive evaluation that he was provided showed that he had low average intellectual potential, but that was probably a low kind of estimate based on the fact that his ability to test was compromised by the fact that he couldn't hear and that he hadn't had any previous education. So the other important thing to know is that Miguel's parents are Spanish speakers only. They don't know any English. And so we all know that IDEA is a statute that incorporates a lot of parent participation. And so in order to have that parent participation, when parents don't speak English, you need to make sure that translators are there. And a lot of times that opportunity was not provided to Miguel's parents. But we'll keep moving to the next one where we get a little bit into how Miguel wasn't provided the accommodations that he needed. Most of the deaf community agrees that American Sign Language is the best language to learn as someone who is deaf in America. It is a language unto itself. It has its own syntax and grammar. It is a full language on its own that is distinct from English. But there wasn't anybody at Sturgis who was trained to be an interpreter in ASL or to teach ASL to Miguel. And instead, what they tried to do was get Miguel an aide, this Miss Cunningham, and allow her to learn something called signed English, which is essentially trying to use ASL signs in English grammatical and syntactical order to approximate English. It's slow, it's clunky. ASL is far superior as a visual language. But um, she actually was learning as she went. And the thing that actually ended up happening was that Miss Cunningham and Miguel ended up kind of creating their own hodgepodge language that only the two of them could understand. It was never actually anything um, recognized as an official language. And so his ability to access his education was severely compromised by this lack of effective communication. And we'll keep going. So Miguel's there in Sturgis, and he ends up attending Sturgis schools for 12 years. So if we remember that he's 9 when he starts there in 2004, he ends up being 21 by the time that he moves on. And he doesn't graduate from Sturgis. We'll see in a minute that he ends up at the Michigan School for the Deaf, which is a much better place for him. But while he's at Sturgis, they never have this qualified sign language interpreter. And like I said, the signing system that was created between Miss Cunningham and Miguel ended up being something that was just between the two of them. It was ineffective as a way to provide Miguel access to his education, and so he was never provided a FAPE. The problem was that because Miguel's parents were Spanish speakers only, and they didn't get consistent interpreters at their IEP team meetings, they were not always informed of how well he was doing or what the issues were, what the barriers might have been. The fact that his IEP goals were set very low didn't occur to them as a problem because, as we'll see in the next slide, Sturgis routinely granted Miguel A's and B's. They put him, oh, actually, this is his cochlear implant. We'll get to the A's and B's in a second. So in 2012, this is 8 years after he's started at Sturgis, he gets a cochlear implant. Now, he was profoundly deaf when he showed up, so he couldn't detect any sound. So the only access that he had was through the visual language that he and Miss Cunningham created. But with the cochlear implant, you think now he's got access to sound. Hopefully, he'll be able to pick up some English. The problem is, and a lot of people know this, that there are certain windows to language development in early toddler years that tend to close. And so for folks who are hearing, who are immersed in a language-filled environment like most of us, we are picking up on a lot of the language structures as we grow. Syntax, grammar, everything that we kind of take for granted that we know and understand about language, and what makes it easy for me to kind of communicate to you and for you to kind of guess a little bit about where I'm heading in my next sentence or things like that. Miguel never had. So even though he's introduced to sound at, age, 8 years after he shows up, so he's 17, he gets his cochlear implant. He can detect sound, but it's not unlike what Peanuts characters hear adults. It's wah, wah, wah. This is pretty much what Miguel can interpret. He's not getting a lot of quality information out of the sound. So they also reduce time with the aid. There's another student who gets a qualified sign language interpreter. And so that just adds a bit of insult to injury, knowing that Sturgis probably could have provided him with one and didn't put in the legwork. So this is the next part where we go through kind of what Sturgis had been doing to represent his progress, which was giving him A's and B's. They put him on the honor roll that actually had no bearing on what he was actually able to internalize. The education he was able to access was minimal. The learning that he did was minimal. But throughout those years, Sturgis was representing that he was on track to earn a high school diploma until March of 2016, which is months before his supposed graduation. And the school tells his parents that he's not getting a diploma. And part of the reason that they came was that so he would be able to get the support and services he needed, because he wasn't getting any kind of education where he was, to live an independent life. Part of that to them was a high school diploma. And so they're understandably confused and a little bit outraged. So they start seeking help. They end up connecting with Disability Rights Michigan so that they can start advocacy. Now, at the start of the advocacy effort, and I'll call them DRM, Disability Rights Michigan, um, DRM works with Miguel and with Sturgis to incorporate the Michigan School for the Deaf. Michigan School for the Deaf, like many state schools for the deaf, are an option anytime a student is being educated in a public school and is deaf, and they may need additional supports and services that the local school can't provide. The School for the Deaf um, was never considered at Sturgis, and it's unclear why that never happened. But when we started advocating for Miguel at DRM, because I was there when that happened too. So I say we, but it wasn't Edmund or Weicker. Um, but DRM's working with Miguel. They get him into Michigan School for the Deaf. And so he's starting to pick up ASL now that he's immersed in a language that's visual, that's like a full visual language that allows him access to his education. And so he's starting to grow by leaps and bounds. But his initial ability to communicate at the time of transfer was, like it says here on the slide, below the first percentile in understanding sign language, because it wasn't sign language that he was learning with Miss Cunningham. Despite that, he continues to make gains, and eventually they start to find a path for him to actually achieve what is necessary for getting a diploma, and that graduation date would be 2020. 16 years after he initially starts at the Sturgis School District in 2004 when he was 9. So that means that he's 23. And if you're curious about why he's still eligible for special education at that age, it's because in Michigan, you're eligible for special education until you're 26. So it may not be the same in other states, but we'll keep going. And this is the run-up to our litigation. In the run-up to litigation, we have Miguel evaluated so that we can understand what his level of cognitive ability is, what other issues might be at play for him, considering what he's experienced in Sturgis. We contact Dr. Peter Isquith. It's fantastic. He's a psychologist who works at Boston's Children in Massachusetts. He evaluates Miguel and confirms that he has an average kind of intelligence. And, this may be something that is reiterated later on, but it's an average kind of intelligence based on his nonverbal visual functioning, and that he might have been eligible for attending college if he had been afforded appropriate language supports, some way to acquire language, a first language, when he was at Sturgis. Because he wasn't afforded that opportunity to acquire a first language, he never really had a meaningful opportunity to access his education. And because of that, those two things, he's probably limited to unskilled labor. He has higher risks for mental health issues, and he will have difficulty living independently. Now, these are concerns that we're going to revisit in terms of damages, because when we move on to litigation, we're going to ask for a host of things, and we can move on now. This is the legal proceedings. We start off with a due process complaint. And like I said, some of those damages that Dr. Isquith highlighted, the inability to work outside of unskilled labor, the concerns about mental health, the concerns about inability to live independently. A lot of these impact his future wage earning capacity, which is something that eventually we get to hire a vocational expert and an economics expert to estimate the damages done to his ability to earn wages. And these kind of financial impacts will be important later on, as we'll see. The other impacts to his ability to live independently and to have these mental health risks were something that we thought we could pursue as well as emotional distress damages. at that time, emotional distress damages were still available. This due process complaint is filed in 2022, a year before Cummings v. Premier Keller Rehab is decided in the Supreme Court, which we'll also get to later. Um, the other part that we request is relief for the family as well, because another issue that we brought up was that the family wasn't getting appropriate translation services. They weren't able to meaningfully participate in IEPT meetings. And so we were hoping for some remedies for them. Um, now, after the due process, um, I think we got to go back one more. That one. Forward one. There we are. Um, okay. So with all those damages in mind, we file in due process and we bring claims under IDEA, we bring claims under ADA, we bring claims under 504. We think that ADA and 504 as freestanding independent claims are something that Miguel could pursue because he was not afforded effective communication. He was not afforded an equal opportunity to access his education. And under IDEA, he wasn't provided a FAPE. All of these things are true. And at the due process hearing, the independent hearing officer, uh, he's an ALJ, an administrative law judge. I call them ALJs. I know the statute says it's an IO, but the ALJ dismisses the ADA Section 504 and the state Michigan's Persons with Disabilities Civil Rights Act claim. He dismisses those early on in the due process. And so we're moving forward with due process only under the IDEA claims. So before trial, we end up at mediation. We settle the IDEA claims alone, and we're able to get significant relief for Miguel in the short term, which was our goal. We knew that we still had these other claims under Section 504 and ADA, but we want to make sure Miguel's set up. He was succeeding at the Michigan School for the Deaf and growing, and so we wanted to keep that placement. We get that in the settlement. We want to make sure that if he does have the opportunity to pursue post-secondary opportunities, he has some money to do that. We set up a small fund for him to pursue those kinds of opportunities. We get sign language instruction for Miguel and his family so that they're able to communicate as a means of making up for the fact that the parents weren't able to participate in his education earlier. Then we also ask for attorney's fees. These are things we all get. And under IDEA, this is a pretty comprehensive settlement. For all the relief that IDEA can afford, we're checking a lot of the boxes. Attorney's fees, comp ed fund, continued placement, and then this sign language instruction for Miguel and his families. We've checked a lot of the boxes that we could check for IDEA relief. It's important to note that the settlement doesn't release Miguel's Section 504 ADA claims. So to us, those are still viable. And then we're moving forward into district court. We file in district court, and this is, no, it was not 2020. What year was it? Well, I think it's October 2018. Is what it says on the slide, and I'm going to trust the slide. The ADA claim we file in the Western District of Michigan is focused on the lack of the sign language interpreter, denial of access to extracurricular activities, and Sturgis's deliberate misrepresentation of his progress. We seek compensatory damages for emotional distress, lost income and earning capacity, and other harm. Sturgis moves to dismiss, and the court agrees. In the next slide, they say that this is the clause in the subsection of IDEA that controls exhaustion. And we didn't fully exhaust Miguel's claims for the 504 and ADA because we didn't complete the due process administrative hearing. And this clause has some history that I'm going to go over real quick. In 1975, IDEA's predecessor was passed, and it took a while for the Supreme Court to figure out between IDEA and Section 504, which also existed, even though the ADA didn't exist yet, what the rights were for students with disabilities in the educational context as between IDEA and Section 504. In a case called Smith v. Robinson, the Supreme Court decides that it's clear to them that Congress intended IDEA to be the sole vehicle for protecting students with disabilities and their civil rights in the education context. So they say once you're in IDEA land, that's the only avenue for relief. You're shut out of getting any kind of relief from other sources. Now, Congress disagrees with the Smith v. Robinson decision and makes it clear that they weren't trying to limit students with disabilities in receiving protection from other anti-discrimination statutes, such as Section 504, such as the ADA. And so they draft this subsection as a fix to that in response to that Supreme Court decision. And it's clunky. I don't like reading signs, but I'm gonna read this one just because it's difficult to understand. So nothing in this chapter, which is IDEA, nothing in IDEA shall be construed to restrict or limit the rights, procedures, and remedies available under the Constitution, the ADA, Section 504, or other federal laws protecting the rights of children with disabilities, except that before the filing of a civil action under such laws, seeking relief that is also available under IDEA, the procedures of IDEA, subsections F and G, shall be exhausted to the same extent as would be required had the action been brought under IDEA. It's confusing. And the federal courts in the different circuits have been interpreting it in different ways, which is one of the reasons why Perez takes up the case at the Supreme Court eventually. It's confusing. There's a circuit split. Some of the circuits say that what matters is the kind of relief that you're seeking. If the relief that you're seeking isn't available under IDEA, you don't need to exhaust. Others say that it matters what your ultimate issue is. Is it education related? Then it has to go through IDEA due process first. In the Sixth Circuit, they understood it to mean that even though these are Section 504 and ADA claims, they still needed to be exhausted through IDEA. Judge Maloney dismisses Miguel's case before we get to the merits. And then we appeal to the Sixth Circuit. At the Sixth Circuit, they affirm Judge Maloney 2-1. We do get a dissenting opinion from Judge Stranch, which was very good. And it noted that there was this other thing that we'll talk about a little bit, Honig veto. But the majority says this exhaustion requirement applies because the crux, the gravamen, the essential issue with Miguel's claim is that he was being denied a FAPE. And that's an analysis that comes from a different Supreme Court case, Fry v. Napoleon Schools, another Sixth Circuit case that got taken up to the Supreme Court and decided not long before this 2021 decision. And so they're applying that analysis in the way that they think is correct. And so they uphold the dismissal. The majority also rejects this futility argument that what we did was get all the relief we could have under IDEA. And the claims that we're bringing in federal court were already dismissed from that proceeding. There was no way for us to get any of the relief that was available under those statutes, and we got full relief under IDEA. They rejected that based on an analysis under Ross v. Blake, which is a Prison Litigation Reform Act case that also requires administrative exhaustion. And that case determined that judge-made exceptions to administrative exhaustion should not stand. So if judges believe that there's no way for someone to get relief through the administrative process, that it would be futile. The judge says, okay, well, you can just skip the administrative process. Ross v. Blake says judges can't do that. Now, Judge Stranch had a different take. She looked not at Ross v. Blake, but at Honig v. Doe, which was issued not long after Smith v. Robinson. So it's still in that formative era when IDEA, 504, and these new disability rights are being kind of the Supreme Court's wrestling with them, figuring out how they work. And Honig v. Doe is based on an issue that involves behavior and stay put, but some of the language in Honig v. Doe recognizes that the original congressional intent behind IDEA or its predecessor was that you shouldn't have to complete the administrative process if it would be futile. So there's an argument that Honig v. Doe recognizes a futility exception, and we'll also talk about that some more as well. But after the Sixth Circuit affirms dismissal, we're going to the Supreme Court. We apply for certiorari after the en banc review is denied. They grant the writ, and we're off and running. And it's a great team that we have. The disability rights Michigan attorneys, myself, and some others were joined in the primary phases of litigation up to this point by folks at the National Association for the Deaf. We're great. Ellen Seidman, who is a regular at COPA. She's part of their amicus committee. She's a great attorney. And then at this level, we're joined by an attorney, Roman Martinez, and his firm, Latham and Watkins. Roman Martinez used to work for the U.S. Solicitor General's office. He actually argued for the United States position in Fry v. Napoleon. So he's well versed in special education. He's well versed on how the Supreme Court works. He was a phenomenal attorney to work with at this level. And so with that team, we get into the Supreme Court based somewhat on this kind of circuit divide and how the Supreme Court's looking at 1415L, which is that subsection concerning the exhaustion. And so the Solicitor General gets pulled in. They're putting an amicus brief together. It's in support of Miguel. And then what happens then is the Supreme Court decides Cummings v. Premier Rehab Keller, and it essentially says that emotional distress damages are no longer available under federal anti-discrimination statutes that are rooted in the spending clause, because the spending clause is in the nature of a contract. The federal government says, here, I'll give you some money, some funding, if you agree to these terms. And so the court considers the remedies that you would typically get out of a breach of contract claim to be the universe of remedies that the government would expect to be on the hook for if a school district doesn't live up to the obligations that they take on by accepting the funding. And typical contract remedies don't include emotional distress damages. And so there's a question at that point, do we still have a claim for Miguel? Because some of what we were hoping for was emotional distress damages. We brief that issue. We tell them, no, it's not just that. It's the lost income, diminished earning capacity, among other things. And then after oral argument in January, the Supreme Court decides in a unanimous decision in March, which is a pretty quick turnaround. You know, the oral argument was in January. We get a 9-page unanimous decision from the Supreme Court, about 2 months later. And it was that the minority position that it really turns on the relief you're seeking. If the relief that you're seeking can be provided by IDEA, you have to exhaust. If the relief that you're seeking cannot be provided by IDEA, then you don't need to exhaust. which means that you can have parallel tracks. You can file independent ADA claims, 504 claims, so long as the damages you're seeking cannot overlap with IDEA. If there are things that you're seeking that might be addressed by IDEA, you still have to exhaust. But if you're clear of anything that IDEA would be able to provide, you can file independently without going through administrative hearings. Now, that's good news. That's good news for Miguel. It opens up opportunities for advocates for students with disabilities. The one thing that the Supreme Court didn't do was address the issue of whether Honig v. Doe actually creates a futility exception. Futility is another way that you might be able to skip that administrative process if you can demonstrate that it would be futile to go through with it. And so it's an open question still. However, the reversal results in a remand. The remand ends up back in district court. We settle soon after. And that's how Miguel's story ends. And he does get a favorable settlement. It does take until he's about 27 that he gets relief, which is staggering considering that it's about 17 years that he was not provided, or no, it was 12 years he wasn't provided what he needed. And then it took about 5 years to get relief. But the key takeaway from a legal standpoint here is that that subsection of IDEA that governs exhaustion turns on the remedy sought and not the underlying harm. And we've talked a little bit about how you can move forward independently, 504 section 8 or section 504 ADA claims, and settlement of those claims do not forfeit your right to claims under the other federal anti-discrimination laws. Although it's my strong instinct that school districts have now incorporated waivers of Section 504 and 88 claims into these kinds of settlements on a regular basis to prevent exactly this from happening. But as advocates, it's important to remember that if you do see that language, and if you are in a due process hearing that is just about IDEA, you need to value those Section 504 and ADA claims and make it explicit that you're giving something away, or else don't give it away. Now, we're going to transition to the pop quiz question, and then we're going to go into the second part of the presentation. So the question is, what legal movie's riveting conclusion turns on an expert's testimony concerning the finer points of different vehicle suspensions and positraction? This is unrelated to exhaustion, but it's a fine film, and I encourage anybody who hasn't seen it to see it. As the results are rolling in, I do see that many people have seen it. My Cousin Vinny, Joe Pesci, Marissa Tomei. Highly recommend. All right. And now the second part, we're going to talk a little bit about Perez and Cummings, how they kind of shape the 504 ADA claims that we can make. We're going to talk a little bit more about Honig and the futility exception, where it is now. And then we're going to revisit Al-Zandani, which Jacqueline brought up in our first session today, that it relates to the Sixth Circuit decision saying that there was no systemic exception to administrative exhaustion. And we're just going to walk through these, just giving each one a little bit of a fuller treatment, and hopefully it will provide some helpful clarification. So we're going to run through Perez and Cummings again real quick. Like we just talked about, the key takeaway of Perez being that the exhaustion turns on the remedy you seek. For IDEA typically we're talking about compensatory education. It can also be continued placement. But when we're talking about remedies that IDEA can't provide, then we're able to move past the exhaustion requirement. Um, Cummings. Now, we talked a little bit about Cummings. It directly dealt with Section 504 as a spending clause statute, but its reasoning extends beyond Section 504. It extends to any spending clause statutes, arguably, that include the possibility of damages for emotional distress, that those damages would now be off the table. For the other anti-discrimination statute that we have for folks with disabilities, the ADA, it expressly incorporates Section 504's remedial scheme, even though the ADA was not promulgated pursuant to the spending clause. So even though it isn't a spending clause statute, it still gets drawn into this Cummings analysis because it expressly incorporates Section 504's remedial scheme. And so there's a case out of the Western District of Michigan that dealt with this issue and what damages remain. It's a case that I think does a fairly good job of trying to analyze these issues. It says that emotional distress, loss of consortium, these damages are equally unavailable under Title II as they are under Section 504. Although there were other damages in Smith v. Kalamazoo that were permitted to go forward. Costs, lost wages for parents who were drawn into having to care for their student because of failures of the school. Times when the student would require hospitalization, the cost of the hospitalization, other kinds of money-based kind of damages. So the other thing is that just to round out the kind of damages picture, punitive and exemplary damages are unavailable under both. Barnes v. Gorman forecloses punitive damages, and exemplary damages are also a part of the contract theory, that those aren't typical remedies for a breach of contract, and so they don't allow them in these to remedy these kinds of concerns. So what survives? The takeaway is that last line, that forward-looking injunctive relief and backward-looking compensatory damages for concrete money-based losses are what survive. So that's important to remember as advocates. And here's just a little bit of a breakdown. I have talked a little bit about all of these. It's just a nice little setup that if folks want, when they have the PowerPoint, they can look at it. The one thing that I'll say is that the viable claims in that forward-looking injunctive relief, the claims are subject to IDEA exhaustion if FAPE denial is the gravamen in the case. And that's another kind of fry issue that if the FAPE is the issue, you typically have to exhaust because you want a remedy that gets you back to where you would have been, which is typically compensatory education, which is available under IDEA. As a comparison case, I put in KM Knox County Board of Education, which was a Sixth Circuit 2023 decision that involved a student who had misophonia. Her issue was with sound. She found certain sounds intolerable to the point that it would interrupt her ability to access her education. The point of contention between her and the school was that she just wanted a chewing gum ban in her classes. And the school district tried to argue that it was a FAPE denial. And so that was the root issue in the case. But when it comes to FAPE and IDEA, many times people make the comparison that between the FAPE that you're afforded under IDEA and the FAPE that you're afforded under Section 504, what distinguishes the IDEA FAPE is specialized instruction, that you may have a disability, it may have an adverse impact on your ability to access education, but that adverse impact requires specialized instruction for you to be able to access your education. In this case, we're not talking about specialized instruction. This ban on chewing gum is nothing to do with specialized instruction. So that's just a comparison case, but we'll move on. Um, and so the Honig exception under futility, again, here's more information about the idea that at the time when IDEA was new, the congressional folks who passed the act felt like exhaustion would not have to be required in certain circumstances. There's support for that idea here. If you're looking for support, there's some good language here. We're going to keep going because we're running low on time. Now, in the Sixth Circuit decision that the Supreme Court reversed in Perez, that Sixth Circuit decision said that the futility exception that was previously recognized in the Sixth Circuit, because there were two cases that recognized this futility exception. They are Covington and FH. The Sixth Circuit Perez decision said that those were no good, but because it was overturned, that essentially negates its precedential authority. So this is reaffirmed by Alzandani's the concurrence in Alzandani. Judge Ritz said that this reverse decision is at most persuasive authority. So it technically revives Covington and FH as authorities for there being a futility exception. We're going to keep going. The majority in Alzandani, they don't resolve the issue. They say very specifically and narrowly that there is no systemic violations exception to IDEA exhaustion. And so they leave open this notion that there might be a futility one. They do cast some doubt on it because they go back to Ross v. Blake in the final parts of their majority opinion. But these are just some questions that are unresolved that we can think about as advocates that we might want to consider in future advocacy. We're going to keep going. Where other circuits are, we don't need this right now. Okay, now there was in Alzandani this very explicit denial of a systemic violations exception. But what they did do, rather helpfully, I think, was to leave some breadcrumbs for advocates if they're interested in systemic change, what it might look like under IDEA. Because like Jacqueline mentioned too, class actions are difficult under IDEA because it's so individualized. And so Alzandani does some work to provide us with an idea of how we could do that. The middle paragraph is a quote from Alzandani that talks about how if parents win at due process, and if a school district doesn't implement the due process decisions order, then what happens is there's an opportunity for the school district to head back to federal court and seek the implementation of the due process decision in a way that might incorporate other elements of relief, such as hiring more staff, increasing funding, things that an administrative law judge or an independent hearing officer would not be able to order. And that if you have enough students at the same district going through the due process hearing, getting those decisions and moving forward, if the school district doesn't implement them, it can lead to systemic change. That's what Alzandani called spillover effects. Essentially that the coordinated effort to continually challenge a school district when it's failing can result in larger change from individuals if it follows this kind of path. There was a couple of slides that I think I might have, I'm not sure if they're still up. Because we just had a key takeaways. Oh, right. This one outlines a little bit about what I had just been talking about, the spillover effects, and how you continue to file individual due process complaints. When you're doing that and filing those individual complaints, you continue to allege the systemic issues, even though you're seeking individual relief, to try and build a record within the due process hearing that there may be bigger issues at play. The ALJs may not be able to remedy it, but if the school district doesn't implement the due process hearing order, then you may be able to go to federal court and say, I've been bringing this up over and over. The ALJ couldn't remedy it. It's still not being fixed. Federal court, you need to step in. Um, and so there's more in terms of the step-by-step process after this slide that you might go through, or actually, it's right before this one. Um, in terms of laying that groundwork. But here we'll get to the takeaways and then I'll take any questions. The takeaways are essentially, the big points that we've been talking about. The Perez and Cummings decisions change how exhaustion works, how damages can be instrumental in how you go about fashioning your complaints, whether you want to go through administrative due process or whether you have to or not, and what you can seek. The Honig futility exception is still being is an open question, and then Al-Zindani's kind of breadcrumbs for systemic relief. And then if there's any questions, I'm happy to jump in and answer them if I can.
Thanks, Mitch. We'll give it a couple of minutes to see if anyone has any questions to drop in the Q&A. We get a couple answered during the session. I think those are good. And Elizabeth, if you wouldn't mind dropping the evaluation link in the chat box, we can do that as well. But yeah, let's just give it another minute here. Good question. Any updates on how Miguel Perez is doing now?
When I knew Miguel personally, I knew that he was a huge fan of soccer and Mexico's national team. I imagine that he took that defeat at the Azteca rather hard, but I think that overall he's doing well. I haven't been able to check in with him for a while since I moved jobs. Um, but I know he was always a kind-hearted, good-spirited, hardworking person, and I imagine none of that has changed.
All right. And one more. What is the best website for looking up the cases you referenced?
I think that looking them up, even just Googling them, most of the time, Justia, I don't know how to say it, but there are other websites that typically provide free PDFs for most of the case decisions. If you don't have access to Westlaw or Lexis or, other kind of platforms like that.
Yeah, one other that I've used is that's publicly available is the Court Listener.
Pacer Monitor, I think, is another one, but most of the time you can find a free way to access those decisions.
And just to comment, thanks. I love the additional background on Miguel, and I appreciate the update.
Yes, of course.
All right. Thank you very much, Mitch.
Yes.
And before we leave, we're going to have another 10-minute break here from 1:50 to 2 p.m. And if everyone could just fill out the evaluation, this is session 4, and it's been posted in the chat box. Thank you, Mitch.
Thanks, y'all.